Hello, my name is Helen McDaniel, and I would like to register my child in school.
Okay, well, I need you to fill out these paperwork with your child's name
Thank
and
you.
information. You can have a seat right there.
Thank you so much.
You're welcome.
Hello, young man.
Hi. Your child has special needs?
Yes, he does. He has been diagnosed with mental retardation.
Well, I would need for you to talk to my principal.
Is there a problem?
I'm not at liberty to disclose that with you, ma'am. You just have to talk to my principal about that. I can
well, that's
send
fine.
you to our office.
That's fine, ma'am.
Okay. Ms. McDaniel, you have a parent in the building.
Hello. Hi, how are you? Oh, okay, send her right in. Okay, thank you.
Hello.
Hi, how are you?
I'm good.
I'm Miss Kermit.
Hi, I'm Miss McDaniel.
Have a seat, please.
Thank you.
So, how may I help you today, ma'am?
Well, I came to register my child who has special needs in school.
Yes, ma'am.
And for some reason your secretary told me to come in and speak to you. Is there a problem?
Yes. Yes. The problem is, ma'am, is that we don't have services for your child due to our funding. We don't have enough funding.
Well, I thought that every child in America has education available to them. Can you tell me why you don't have the funding? I mean, you have funding for all other kids, so why not my special needs child?
Yes, I understand it. We don't have the funding to give your child the facilities, to give them the teachers, for them to get the extra help they need in order to have a good education. We don't have the funding, ma'am.
Well, I feel that my child has the right to have an education just like any other child, even though he's special needs. So, who should I talk to regarding this? I mean, I know that you're just a principal of the school.
Yes.
Is there someone else that I can speak to regarding this?
Yes, you may speak to the superintendent. If you would like, I would give you her number.
I would like that. Thank you.
Okay. And you may go to the Board of Education.
Thank you.
Thank you so much.
Thank you.
All
Hi.
right,
I came to talk to you about educating my son who has special needs. He
Yes.
has mental illness, and
Mhm.
I feel that every student in America should be able to have an education. And the principal at the school in my district said that there's no funding or facilities for students such as my son. I really find that to be a problem, and I would really like some explanation from you.
Yes, ma'am. I'm so sorry about that. But, like the principal said, your child has exceptional needs, and we are unable to provide funding to give your child private educational services. It's too expensive for our district, and we cannot afford it. There's also things you could do with your child. There's outside agencies you could enroll him in. There's places that offer, speech therapy or any kind of therapy he needs, but we don't have the funding for that.
Well, I'm a taxpayer and citizen, and I feel that
understand.
I should be able to get an education for my son in which I don't have to come out of my pocket because I can't afford these services. I feel like he's a child in America. I'm a taxpayer, and
Yes,
I feel like he should be able to have the services like any other child that you consider normal. And I am really upset by this. I'm not going to stop here. I am going to make sure that children such as my son and other children gain an education as well as any other normal student in America.
Yes, so Mrs. Mills, the District of Columbia, we are unable to provide funds.
Okay, you said that already. That's okay. You just
Hello, this is Ms. Molaski, Superintendent. Yes. Yes. I spoke to Mrs. Mills about a week ago regarding her child. Yes. She's filing suit against District of Columbia. Okay, okay, I understand. Well, we'll have to start getting our lawyers together to fight this case. Okay. Yes. Okay. Thank you so much. Bye-bye.
Court's now in session. Peter Mills Plaintiffs versus Board of Education, District of Columbia Defendants. Case number 39-71, August 1st, 1972. This is a civil action brought on behalf of 7 children of school age by their next friends in which they seek a declaration of rights and to enjoin the defendants from excluding them from the District of Columbia public schools or denying them by supported education to compel the defendants to provide them with immediate and adequate education and educational facilities in the public schools or alternate placement at the public expense. They also seek additional and ancillary relief to effectuate the primary relief. They allege that although they can profit from an education either in regular classrooms with supportive services or special classes adapted to their needs, they have been labeled as behavioral problems, mentally retarded, emotionally disrupted, or hyperactive, and denied admission to public schools or excluded therefrom after admission, with no provision for alternate education placements or periodic review. The action was certified as a class action rule 23 and 2 of Federal Rules of Civil Procedure by order of the court dated December 17, 1971. The defendants are the Board of Education of the District of Columbia and its members, the Superintendent of Schools for the District of Columbia and subordinate schools officials, the Commissioner of District of Columbia and certain subordinate officials in the District of Columbia. Course in session.
Honorable Judge Waddy. Hi, I am Mrs. Apricot. I am on behalf of the plaintiffs, Mr. Mills, and the seven school children.
Yes, ma'am.
The problem in this case that I find is, number one, the genesis of this case is found in the failure of the District of Columbia to provide publicly supported education and training to plaintiffs and other exceptional children.
Yes, ma'am.
Members of the class. 2. The excluding, suspending, expelling, and resigning and transferring of exceptional children from the regular public school classes without affording them due process of law. The problem of providing special education for exceptional children, mentally retarded, emotionally disturbed, physically handicapped, hyperactive, and children with behavioral problems is one of major proportions in the District of Columbia. The precise number of such children cannot be stated because the district has continuously failed to comply with. Would you want your children to be put in this predicament? Would you, if your child had exceptional needs, if your child was deemed behavioral, mentally retarded, would you want your child to be an outcast? Shouldn't we get our children free public education? Why shouldn't our children get free public education? Not everybody can afford an outside private education. How could they? For instance, one of my children, in my case, we have George Little Jr. He's 8 years old. He's 8 years old. He's a resident with his mother, Daisy Little, at 601 Morton Street, Washington, D.C. And an ASDC recipient. George has never attended public school because of the denial of his application to the Maury Elementary School on the ground that he's required a special class. George allegedly was retarded. Defendants have not provided him with a full hearing or with a timely and adequate review of his status. George remains excluded from all publicly supported education, despite a medical opinion that he is capable of profiting from schooling, and despite his mother's efforts to secure a tuition grant from defendants. You see, Columbia School Board of Education is not giving their children the education they need, no matter what kind of condition they're in or what kind of special needs they have. I beg of you
to see forth that the Columbia Board of Education supplies a free public education to these children with exceptional needs. That's all.
Congress had decreed of a system of publicly supported education for children of the District of Columbia. The Board of Education has a responsibility of administering the system in accordance with the law and providing such publicly supported education to all children of the district, including these exceptional children. Defendants have admitted in these proceedings that they are under affirmative duty to provide plaintiffs in their classes with publicly supported education suited to child's needs, including special education and tuition grants, and also a constitutionally adequate prior hearing to periodic review. And they also admitted that they have failed to supply plaintiffs with such publicly supported education and have failed to afford them adequate prior hearing and periodic review. On December 20, 1971, the plaintiffs and defendants agreed to accord sign an interim stipulation and order which provided in part as follows. On February 9, 1972, the Board of Education passed a resolution which included the following: special education. All vacant authorized special education positions, whether in the regular impact aid or federal budgets, shall be filled as rapidly as possible within the capability of special education department, regardless of the capability of the department to fill the vacant positions. All the funds presently appropriated and allotted for special education, whether in the regular impact aid or other federal budgets, shall be spent solely for special education. The board requests the Corporation Council to ask the United States District Court for extension of time within which to file a response to plaintiffs' motion for summary judgment in Mills v. Board of Education on the grounds that a board intends to enter into a consent judgment declaring the rights of children in the District of Columbia to a public education, and the board needs time to obtain from the Associate Superintendent for Special Education a precise projection on a monthly basis the cost of fulfilling those budgets. The board directs the Rules of Committee to devise as soon as possible for the purpose of the Mills v. Board of Education rules defining and providing for due process and fair hearings, and requests the Corporation Council to lend such assistance to the board as been necessary in devising such rules in a form which will meet the requirements of Mills v. Board of Education. It is the intention of the board to submit approval by the court in Mills v. Board of Education a memorandum of understanding setting forth a comprehensive plan for the education, treatment, care of physically or mentally impaired children in the age range from 3 to 21 years of age. It is hoped that the various of the District of Columbia agencies concerned will join the board in the submission of this plan.